Hello, everyone. My name is Jim Carmichael. I am one of the Planning Committee co-chairs here at the AAPJ, the American Association of Patent Judges, with our president, Judge Murriel Crawford, presiding, and our president-elect, Judge Hubert Lauren. For this meeting, we have in attendance not only the current Chief and Deputy Chief Administrative Patent Judges of the PTAB, but every living former chief as well. We are so grateful for the participation of all of these leaders of the board, past and present. We are holding this meeting to honor their service and gain a historical perspective of the board, including the development of AIA trial procedures. I cannot think of a group of people that has done more to promote the progress of the useful arts than this group here tonight. This is especially important today as the useful arts have run to the rescue of the entire planet in the battle against the COVID-19 pandemic. A heartfelt thanks to all of the leaders of the board that got us to this moment. Tonight, each speaker will provide about 10 minutes of remarks in chronological order, beginning with Bruce Stoner and ending with Deputy Chief Judge Bonilla and then Chief Judge Bolick. First up, Bruce Stoner was the Chief Judge of the board from 1995 to 2003. He is now an attorney with Green, Blum, and Bernstein. Judge Stoner, take it away.
Jim, thank you, and thanks to the committee for inviting me to participate in this event. It's good to be here in quotation marks with you in this virtual manner, a strange manner in which we've grown accustomed during the last very strange year. As a visitor from another century, are we having some feedback problems somewhere? Okay. As a visitor from another century, let me tell you that I joined what was then the Patent Office in June 1970, which is now nearly 51 years ago. I suspect that was before at least some in the audience were born. It was 35 years ago around this time of year that I began my duties at the board as an examiner-in-chief, using that old title, and more than 25 years ago that I became Chief APJ. Not quite 18 years ago, I graduated to whatever my present state might appropriately be called. I wanted to comment on that photo that accompanied the flyer for this meeting. It was taken sometime in 1998 in advance of an international patent appeal examination symposium in Tokyo, when it was decided that I needed an official photograph. It was made over at the Department of Commerce, cameras and flags not yet having crossed the river to Crystal City. And a comparison between that photo and what you see on your screen today reinforces the reality of the passage of time. In the course of this talk, I will undoubtedly mention a handful of people that I worked with. There are many others who are worthy of mention. Not naming each is a risk I take, knowing full well that any success the board had during my time depended on a whole host of people of all position descriptions. I am and will remain eternally grateful for all the wonderful people I met and worked with during my years at the board, and for those others as well. I began learning the patent trade when I joined the office as an examiner in Group 310, a mechanical examining group handling patent applications, where I became a primary examiner in 1977 and later became an SP in 1983. Like so many others, I attended law school while working at the PTO. I was selected to the board in 1986. Not long after the merger of the old Board of Appeals and Board of Patent Interferences, when Saul Sirota was acting chairman of the board. That was a very interesting time because it really foreshadowed the kind of organization that the board would become. I had the good fortune to serve under Saul and Ian Calvert. Ian Calvert was then the vice chairman, and he was formerly chairman of the Board of Patent Interferences. Later, Saul became the first chairman to have the title Chief Judge, and Ian was the first to be called Vice Chief Judge. Fred McKelvey succeeded Saul in 1994 as Chief Judge. Beginning in May 1995, I served as one of 3 vice chiefs to Fred McKelvey, along with Rick Schaefer and Gary Harkcom. I think Fred and Ian always like to think that it took 3 of us to replace Ian, and that was actually true. When we sat down and figured out what all the duties were, we were astonished at how much that had to be divided up to be done. I became acting chief upon Fred's retirement. That's actually Fred's first retirement. I don't know how many of those there were, but that was at the end of September 1995, and that selection was made as permanent as such things are in March of 1996. And I served there until October 2003, when I retired and entered private practice with Greenbloom, Bernstein, and Reston. There's a temptation to start spinning stories about the folks I worked with at the board. Getting the opportunity to work with Fred was in many ways life-changing. He had a comprehensive knowledge of how the PTO worked, a knowledge that spanned the PTO's relationship with other parts of the government, and burrowed down to the details of how even obscure parts of the PTO worked. His knowledge of the personalities of the people in the Department of Commerce, Department of Justice, in the courts, and at home in the PTO, and what all of that meant in terms of getting things accomplished was something I had not previously witnessed at close hand. And when he provided his 3 new vice chiefs with a pamphlet about managing the boss, I was convinced he was reading our minds. I've looked in vain for that document in my files and have not found it, but hope abounds. We'll leave those stories for another time. Our unifying topic today, as I understand it, is post-grant review in its various forms and how we, the board, if you will permit the possessive reference, got there as an organization. I would encourage all of you who contemplate this matter to remember interferences as they were used and administered after the change of law in 1984. An appreciation of that time is helpful in understanding what the board did, at least initially, with post-grant review. Fred, Ian, and others had a vision of what interference could be at a unified board that was capable of deciding and charged with deciding both priority and patentability. And that was first expressed in the MPEP about 1984 in a document that was largely written by Fred. The reality of the practice in the 80s and the early 90s was somewhat different as a result of the transition from separate boards to a unified board. And it was to be expected as you were bringing a group of diverse folks together to take on obligations and duties that they hadn't had previously, even though they were capable of doing them. There was a time that there were some disconnects and struggles. But the creation of the trial section in the late 90s was an act that actually brought that vision to reality. And it was a reality that I believe was hastened by the evolution in practice from one that was principally focused on determining priority, as we all learned to think of interferences, to one that was increasingly focused on patentability, a change that was driven by the parties who appeared before the board. As a young primary examiner in the late 70s and early 80s, I had an interest in reissue. And when it came into effect, ex parte re-examination as well. It helped that I was willing to take on such cases while most of my colleagues knew better than to volunteer. Volunteering provided me a lot of opportunities and a lot of headaches during my career. And indeed, I was lucky enough to be involved in some of the early contested reissue proceedings under what was known as the Dan Amendments. For those of you who want to delve into the past, there's one for you. At the board, I had the fortune to be assigned a number of decisions to author a number of decisions in re-examination, including a few of those in which the office of the then Assistant Commissioner for Patents, through an entity colloquially known as the Fraud Shop, made rejections for violations of the duty of disclosure. The major public complaints associated with ex parte re-examination back in the early 80s were that, one, re-examination took too long, special dispatch notwithstanding, and two, that examiners gave up too readily, especially since early on re-examinations like reissues typically went back to the same examiner who examined the underlying patent application. This, of course, was well before the idea that re-exams should be assigned to someone other than the original examiner, much less before the central re-examination unit came into existence to provide expertise and special handling of re-examination procedure. It was also before the time that third-party requesters got a serious chance to explain why the patent owner was wrong in opposing the requester's proposed rejections, and to have that clash of ideas that we've come to understand. So the first glimmers of inter partes re-exam arose from dissatisfaction with ex parte re-examination. Interferences were being increasingly used as patent cancellation proceedings rather than priority contests. And this led to a point in which the office got sufficiently interested in the late 80s and early 90s to invest some time and money in formulating a process and writing some draft rules. Those of you who remember Al Smith, the mechanical group director, Al and I were charged with writing the first crack at those rules. We basically cribbed them from the ex parte rules, but nonetheless, we were trying to set up an inter partes process at that point. That effort really went nowhere for a number of years, and then surprisingly, the law enabling inter partes re-exam was adopted in 1999, and Al and I were tasked with dusting off those rules, tuning them up, and sending them out for the rest of the office to weigh in. As I recall, what was finally adopted was pretty close to what we had written earlier, but that's only because there was a mandate to make inter partes look like ex parte, but with opportunity for the requester to respond to the patent owner's arguments. You have to understand that there weren't very many re-examinations in the early days. Although the office expected re-examination, what we now call ex parte re-exam, to be a big deal, and it geared up to handle as many as 10,000 proceedings per year back in 1981. It in fact turned out to be 2010 before the total number of re-exams actually reached 10,000. So it took about 30 years to get off the ground. In my time, and in most years before the late 2000s, there were at most a few hundred, 200-300 ex parte re-exams filed each year. By 2009, that annual number had reached nearly 700, and when coupled with the roughly 300 or so inter partes re-exams being filed annually, which were just then hitting their stride, there were about 1,000 or so re-examination cases per year. Interferences, of course, had fallen to a few hundred and then down to a handful, and that number just continued to decrease. And historically, there's been about 1,000 reissue applications filed annually. So that's kind of the universe of these kind of cases that people were looking at. Everybody knows, I think, that the statistic on inter partes re-examinations, there were ultimately less than 2,000 of those filed in their 12 years of existence. And some of those, of course, still are pending, demonstrating that it was a cumbersome process. All of those numbers play a role in later calculations and perhaps miscalculations of the expected popularity of post-grant proceedings. As inter partes re-exam began to slowly phase in and were found to take forever, and that was at the very end of my time, it became clear both internally and externally that something more robust and quicker was going to be needed. Also became clear to me that in light of the declining number of pending interferences as a result of the streamlined procedures piloted by Fred McKelvey and the other members of the then newly organized trial section, as well as a turning tide on the number of pending ex parte appeals at that particular point in time, the board might have the resources and know-how to make post-grant review happen entirely at the board. The fact that other parts of the office, notably the patents operation, were already thinking about new programs provided added impetus for the board to get involved at the outset when it might help shape the process, not after a new process was in place. All this, of course, was when the thought was that there would be a program that mirrors present-day PGR program of post-grant review. Inter partes re-exam would go away. We weren't at that point envisioning inter-parties process as it exists today. Ex parte re-exam would remain. What I expect everyone else will talk about is the rest of that story within their own times of influence. But you need to know that we began pulling together today's procedures back in 2000, 2001, before the first version of the 21st Century Strategic Plan was published in June 2002. And that was, of course, in response to user feedback that we had at that time solicited from the AIPLA and the IPO. There's probably no doubt in anybody's minds that those plans were founded on an interference practice as it came to be in the trial section. I guess at this point I need to say I'll reserve whatever time remains to me for rebuttal later on. And again, thanks for inviting me to participate. Jim?
Thank you, Judge Stoner. I'm impressed at the foresight you had to get started working on trial proceedings way back when. I was there with you, and frankly, I thought it was a little premature, but it turned out not to be, because it all came to pass. So well done. Next, we have Mike Fleming. Mike was the chief judge of the board from 2004 to 2010. He is now an attorney with Irell and Manila. Judge Fleming.
Thank you, Jim. To start off, I would greatly say that I appreciate having a chance to be part of this program. And it's also interesting that I think it's important that somehow maybe the board might consider a more formal way of writing up the history of the board and its impact on the greater scheme of helping our industries be competitive in the world. And I also would like to thank Bruce for laying a good foundation for when I took over. And I want to start on the outset to say I'm going to refer to we, what we did during my time. Just as Bruce mentioned, that it was a huge team of people working together to accomplish what we accomplished during the time that I was chief judge. And I'm not going to try to name all the names because it was so many, but just remember when I say we, that's many, many people. To add to the story of how we ended up with post-grant review and IPRs is that what Bruce didn't mention was the politics that were happening on the Hill. And the politics is that we had one industry, which was the software industry, which wanted to abolish all patents. And then we had the pharmaceutical industry that wanted to strengthen patents. And to this day, those two competing industries are grinding away at how our process is going to be. And by no means is it over. The post-grant review is going to be ever changing depending on how the politics are such. But when I just before I became chief judge, I was called into the director's office, and there was representatives from the White House, and they were sounding the alarm. They really felt that the software industry was gaining traction down on the Hill, and they wanted to know if there was anything that we could do to go down on the Hill to explain that maybe we could craft a process. And what Bruce has said is that we did have a process that worked, and that was the revamping of the interferences, where the first year was essentially a post-grant review. So I had something that I could sell. I went down to talk to those people down on the Hill, showing how we had a success in having an inter-party review of a patent in an interference, and that we could do it in a year. Because what Bruce didn't mention is before the interferences were redone, it was taking 20 years on some of them. And we were able to consistently have these interferences with a patentability being decided in 1 year and priority decided in the second year. So that was our start of crafting this law. And it gave us an in because it allowed us to have a voice down on the hill on crafting this statute. And there was, again, many people that were working with me on coming up with specific language to address each of the stakeholders' concerns, and it was quite an effort. But my main objective was to come away with a statute that was doable for the board. I was representing what we could do. And there's a couple of things that were very important. One is we learned from our mistakes on the statute that for the inter-party re-exam. Everything was hardwired. Like everything was in the statute. There was no way that we could change anything. And I went down there saying that we want to have strong rulemaking ability and not to hardwire the process. Allow the director to promulgate rules that would establish what the process would be. That was a very hard sell, but we were able to get it done. Another important part of the statute that was that I fought, what we fought very hard for, was the idea that these things could be done in a year, and so how could we make sure that this was going to be done in a year? It was important that by the statute that the process really had to be an upfront process where the petition brought forth all the arguments and that then the patent owner had the ability to respond. So it was a very compact way of doing things. And that has survived to this day, that concept of indeed, you're going to have to bring forth and you can't just hide and wait at the last minute and spring something on somebody at the end. That was important because that was the only way it was going to be done in a year. So working with the statute, that was one aspect of what we did during that time. Another aspect is we had to prepare the board to be able to, in fact, be ready when post-grant review happened. And there was a number of initiatives. First thing was to reorganize the board into particular, I don't remember exactly our organizational chart, but it essentially was divisions where we had lead APJs that led each of the divisions, and that we were able to provide a organizational way in which the board could become bigger and that information could be brought to all the APJs in a uniform fashion. Another aspect was that we had to go from paper to electronics. And that was a huge effort, and it cost an awful lot of money because we had to scan all these paper files into the system, and that we had to be able to provide equipment so that APJs could work as I assume we're working now, so that you weren't having to pass a paper file from desk to desk. I can't tell you what a big effort that was. The other aspect was we were going to need to hire a whole lot of APJs, and how we're going to recruit all these APJs. And it was not going to be possible in our assessment to say, oh, we're going to find all these APJs in the Washington area. So we needed, but we also realized a lot of people weren't going to be interested in living in the Washington area. So Fred had retired, but he wanted to come back, but he didn't want to leave Hawaii. So I said to Fred, okay, you come back, but you can live in Hawaii, but we're going to have this pilot program where you can work remotely from Hawaii. And I sold it to upper management saying, look, if Fred can do this from Hawaii, we could definitely do it from anywhere in the United States. And so the board was the very first organization that actually had this work at home idea, or work anywhere in the United States. And it was through that pilot program. Thank goodness we did that, because with COVID, I'm not sure how the PTO would have been able to function. But again, that was an awful lot of work on Fred's part, as well as all the IT people that worked with Fred to figure out a way to get that done. The technology back then is not nearly as robust as it is today. So there was a lot of glitches that had to get through. The other aspect was just flat out hiring APJs. And that was a difficult task because we needed, and I don't remember exactly the numbers, but because we had a whole lot of retirements right in the beginning of when I took over. But I do remember, I think that we ended up hiring more than 100 through the time. But we also had a lot of people leaving during that time. So in any event, I don't remember exactly how many APJs were by the time I left, but it set the stage for the next chief to ramp up, to be able to have the necessary number of APJs and resources to be able to do the post-grant review, as well as the huge ex parte appeals that we had. One of the challenges during my time is that we had an increasing number of appeals arriving at the board, and this was because of the then administration pushing for the thought that you weren't going to be able to file a continuation. So it left no other opportunity but to go to the board. And so we had an avalanche of appeals because of that, which led to another initiative, and that was to rewrite the ex parte appeals rules, which that was a big effort. And as a result, it was able to streamline the process and lay the groundwork so that the number of appeals could be reduced. And then finally, there was a big worry about whether or not we increase the board size. How are we going to ensure the quality of the work that's done at the board? And how are you going to ensure that everyone is making consistent decisions? And that's where we initiated the presidential opinion process, which was present at the board, but was used at a limited basis. And we ramped it up during my time to be able to communicate to the board and have everyone on the board understand certain policies that the director wanted to make sure we implemented in a consistent way. The other aspect was, again, the idea that hold on just a minute, I got the other aspect is that through the organization, we could have these divisions, team meetings in which those folks could meet regularly, and so that we could discuss certain decisions and whether or not this should be the make sure that everyone across these teams were acting in a consistent manner. So with that, I will again reserve my time for any rebuttal or questions in the end.
Thank you, Judge Fleming, and thank you for accepting the duty of being my official mentor when I joined the board way back when. Appreciate that. Now, after Chief Judge Fleming, Jay Moore was the acting Chief Judge of the board from 2010 to 2011, and Deputy Chief from 2012 to 2014. Notably, Judge Moore was also the president of this association and is currently an administrative patent judge. Judge Moore?
Thank you very much. I have, I guess, the privilege of having been the last vice chief judge of the Board of Patent Appeals and Interferences, and the first vice chief judge of the Patent Trial and Appeal Board, I guess, and also the first deputy chief. And it was kind of that whole switch is just one of those momentous things in life and career that you always remember. But I feel like listening to Chief Judge Stoner and Chief Judge Fleming that clearly I was amongst the presence of giants. Thank you, first of all, to Chief Judge Stoner for having the courage to hire me, one of the first, not the first, but in that first tranche of folks who came in from the PTO from the outside to the board. I think that bringing in some of the outsiders over the years, especially in my instance, helped a lot in our desire to have a litigation sort of style kind of proceeding here at the board. And one of the reasons for that is my first real boss in a law firm, Rudy Hutz at Connolly, Bode, Lodge and Hutz in Wilmington, Delaware. He got me heavily involved in litigation and interference work. And I really did enjoy that in addition to doing prosecution. But when Chief Judge Stoner decided to hire me, I think he may have told Judge McKelvey all of this. And he then, after a few years to make sure I could actually live in Richmond and commute to Crystal City every day, I think he decided that it might be okay to draft me into the interference section. And then I was also in the presence of giants, Judges Schaefer, McKelvey, Torkson, Lee, Lane, Medley, all of whom were wonderful mentors in teaching how to conduct an interference from the inside. It was the system that was set up was so incredibly efficient and effective. I was wholly impressed when I just started, and I really hoped I didn't disappoint folks. Chief Judge Fleming and Harkcom actually persuaded me to lead the trial section, only probably because Jameson wouldn't listen to my pleading that he would be much better at doing it. But certainly Fred, when he retired for the first, second, third, or fourth time, left a trial section in really good order, and it was very easy to run. In 2008, Vice Chief Harkcom retired, well, 2007, I guess, and 2008, I was fortunate enough to have Chief Judge Fleming appoint me to be his Vice Chief Judge. And boy, was that a whole different series of things that we had to undertake. Of course, the board did have a somewhat of an inventory of ex parte appeals that we were trying to get through. So we had a lot of hiring to do. And from early on, the legislation went through several rounds. we were constantly, year after year, providing background information and processes and our predictions on costs and how long it would take and what sort of staff we would require. And that was actually one of the more fascinating parts of being the vice chief judge at that time. Managed to put together a team of people without which it could never have happened. Bunch of the lead judges shortly thereafter. How we're going to do this? What kind of rules are we going to make? How is this all going to function? And just assembling that team to get that done. The vice chief judge is the guy who gets it done behind the scenes. I'm not the idea person. I'm the person who tries to put together the actual operations of the system. And we certainly, when I was briefly acting, we didn't have a whole lot of internal impetus to make too many changes because for that period of time, I was the singular executive at the board. I think at one point I had 107 direct reports. So it got kind of interesting there for a while. But once the AIA actually passed, things got pretty interesting quickly. We went downstairs to talk to the CIO and said, hey, we need a system. And the CIO said, huh? And that was a very interesting year or two of what can we do to create a system? The lead judges were especially involved with the rule process and all sorts of other things to make this actually happen. And to me, that was part of the real challenge of it. But simultaneously on top of all that, we had the fun of opening all of these new offices and hiring judges into them. And designing offices, figuring out how to equip hearing rooms, how are we going to link them? How are we going to schedule them? How are we going to do all this and do trials and do appeals hearings and continue to do the interferences as long as they lasted? Fascinating. We had a heck of an interesting time doing that. A special shout out to Commissioner Focarino, who at that time, she just was wonderful in helping us share the new office space, helping us design it out. Detroit, Denver, Dallas, personally involved in working all of those places to something which could work. And that leads to one of my favorite stories about working at the PTO. I, for a brief period of time, was the only PTO employee in the Denver office. For a few days, it was just me. And the reason for that is there were no permanent employees. And we had opened the temporary office in the middle of the winter. It's February, it's cold, it's -8 degrees, it's high up there in the hills. And I fly in by myself. The office has all been set up wonderfully by the people in the Office of Administrative Services, but it's empty. And I get there early in the morning and I wander over to the GSA office there on site. And we're really happy to have you here. Here's the keys. Like, what? Here's the keys. By the way, the heating plant is turned off. You have to turn it on. Okay, mind you, it's February and it's in Denver. I get into the office, I could see my breath. And it was just so strange being here by yourself, opening a new office. It's like a pivotal moment in the agency, and it was a ton of fun. And we got everything up and running, and obviously we ended up with beautiful facilities in Detroit, Denver, Dallas, and in the Silicon Valley. But my part of it, I feel, was not as the big architect of how do we get to AIA or at the end of it, but really kind of just the person who was in the middle, helping to get it done, and setting up the teams, trying to find the resources and enjoying the heck out of it. So that's about my little piece of it. And I want to thank you for letting me speak to that and tell you my little anecdote about being shivering in the office in February in Denver.
Thank you, Judge Moore. Interesting story about being the only employee at the Denver office briefly. And now with COVID, you can be the only APJ at your own office.
I am right here, beautiful Delaware.
The next chief judge of the board was James Smith. Judge Smith was the chief judge from 2011 to 2015, making him the first chief judge of the PTAB and the first chief judge in the post-AIA era. Judge Smith is currently the chief intellectual property counsel at Ecolab. Judge Smith.
Good afternoon. Thank you for having me. I'll begin with a little bit of personal recollection as well, and my recollection may differ and call into conflict some of former Vice Chief Judge Moore's recollection. I'll touch on that in a second, and after a brief moment in the personal space, I'll move to something I think more thematic before getting back to some other things, perhaps also more infected with the personal space. Much is made now of the fact that there are these 4 additional offices of the USPTO: Detroit, Denver, Dallas, and as we first called it, Dan Jose. So there would be 4 Ds, or San Jose as it actually is. And much is made of the patents operation sharing space with us in those offices. The fact of the matter is, and Judge Moore's recollections touch on this, we realized at the board before others did, and this also goes to something Chief Judge Fleming was speaking about, we realized that having an adequate core of judges made necessary having operations not in Washington alone. And because we realized that, we actually went with the officials of the PTO to Congress to talk about what the implementation of their plan in the AIA would mean if we added to Detroit 4 more offices, the locations of which were not even decided at the end of 2011. We engaged in the conversation with them about the selection of those offices, having in mind as much where good administrative patent judges could be found as where other personnel would be found for other positions at the patent office. And what Jay Moore and I share actually is a very intimate experience with those offices that predate some of their permanent locations and the peopling of them by anybody other than board personnel. I actually was with Judge Moore. It was the first week of January, actually, shortly after the new year in Colorado, that we trudged through the snow to open that office. It was not in the grand Denver office that the USPTO has now on the 13th, 14th, and 15th floors of a Leeds quality tower in gleaming downtown Denver. The first space we acquired, and we actually negotiated this with the government, the board led the effort. It was a bunker, essentially, at an old military facility about 6 miles due west of downtown Denver, which required, you will remember, Jay, a drive through a very winding path between military installations and other government offices before you got to the concrete layer our Denver judges first occupied when the USPTO opened its office in Denver. The office was established and up and running there primarily with administrative patent judges before the addition of different personnel and eventually the move downtown to the large tower only after the government had completed the refurbishment of the 3 floors that we came to occupy there. Similarly, Jay and I hung out in the Detroit office. That office, you will know, is about a mile, between half a mile and a mile east of the Renaissance Center in downtown Detroit, an old Pabst brewing facility that then came to be owned by Sharing Drug, a building also in need of substantial refurbishment. When Jay and I first were hanging out in that office, again, well before it was peopled by other people in the PTO, we were dealing with one of the problems not yet addressed at the building, which was because of some of the things not quite fixed yet in the heating system. If you were there on the wrong afternoon and were on the south side of the building, the temperature might be 85 degrees while the rest of the floor was at 69 degrees. Problems we worked through with extraordinary, quick and able help from people at the PTO and from the government office that handles those kinds of affairs. Similarly, in Dallas, maybe a good year before the permanent facility opened, Jay and I were in another federal building, one building over from the federal courthouse and occupied by several other government agencies. And we turned the key on the opening of that office and were the first two people actually to help the various people install the computers, see the printers were running. And we did all of this while we also did our regular jobs. This was true also in California. California, we now have a lovely facility in San Jose. That's not where it started. It started again, the opening of the USPTO, not with other personnel, but with APJs. That started on a facility somewhere between Palo Alto and Menlo Park, in a facility mainly occupied by the US Geological Survey. The back end of, I think, their 10th building, Building X on that campus, also in need of refurbishment, but very adequate in space. And there were days when on evenings, late evenings, we would leave Dulles Airport, land early evening, go there for work, work among other things to help select the judges who would serve in that office, put in a full day in California, fly back on the red eye and begin our duties the next day in Alexandria. Again, well before the very well-appointed facility in San Jose opened. Meanwhile, of course, Washington was not, the DC office, our campus in Alexandria, was augmented with a facility in Shirlington, where we also had judges. I don't know if judges are still located there. I'm assuming that probably, well, I guess there are no judges in Shirlington now, but for reasons not related to the great assistance that additional location provided for us, even in having more space for the DC operation. All of these personal recollections tie actually to what I think is the biggest theme, which is this: who would have imagined that the BPAI, with its very solid foundations, built by people who you've heard from already in this meeting, forward-looking people who thought about things like what purpose might the rules have to serve eventually? What kind of information gathering and recollection system ultimately serves the purposes of the board 10 years out? How do you keep the various stakeholders in industry and in the economy happy with the operations of the decision makers at the BPAI? The very solid foundation built by the people at the BPAI made for a world where the BPAI, in becoming the PTAB, has resulted in this extraordinary thing. If you ask the 9 justices of the US Supreme Court have you heard the phrase PTAB? What would the acronym PTAB? What would be their answer? Their answer would be yes, because somehow magically this tribunal that is near and dear to all of us has become the central government entity for this big question. How quiet ought title to be for a patent? And not just a patent, but the rights associated with the patent, which are fundamental for how, fundamental in determining how to conduct business, whether it's in the IT and computing world or in the pharmaceutical world. It's the same big question for them. Will I be able to assert my rights? Will others be able to assert rights against me? How strong are these rights, and can they be challenged? And which entity now has more control of that outcome than any in the country? We know the answer. It's PTAB. This is an extraordinary thing. And the significance that the PTAB has taken on with respect to these issues means that the work performed by this group of people, these vice, chief, deputy APJs, and all their colleagues, now in the backward look of history, and even looking forward, has a glimmer to it that perhaps would have been unimaginable for PJ Federico sitting in his office as chief examiner-in-chief decades ago when he was helping Judge Rich write Section 103 of the current patent statute. It's an extraordinary thing, and that we arrived at that place did not come about easily. I, of course, can speak to the challenges we faced during the time I was there. I don't mean to suggest that these were in any way greater challenges than those faced by others, but they perhaps were unique. Chief Judge Fleming spoke about the number of judges at the board at his departure. I can give you the number. It was 95. And at my departure, it was 255. A whole lot of judges between 95 and 255. Here is the big thing, though. The increased number of judges is almost less a matter of historical marvel than this thing. And again, Judge Fleming is correct. Hard to look at any of these facts, this progression of history, without also referring to the political backdrop. The political backdrop around 95 APJs at the time Chief Judge Fleming left the board to go on back to making real money. The interesting thing at that time is one of the big things going on in government and the political discourse was, why ought the federal government to have even one more employee in 2011 than it had in 2010? What was the result? We were not permitted as a board to grow. The 95 judges was not merely the number, it was the ceiling. Now, progress a little bit into that and you'll recognize the enormous challenge that faces. We were on our way to and eventually had 27,000 plus ex parte appeals. We were expecting 350 post-grant cases. I use that term generally to refer to the AIA trials. What happened is we did in fact reach the 27,000 ex parte appeals, and in the first year we had more than 1,500 new trials to hear. How then does that square with a 95 judge ceiling on the size of the board? Here I just think it appropriate to get into another recollection that is a bit more personal. At one point, the then undersecretary, director, and I, we were looking at the numbers. I remember it so well. It was November of 2011. And we'd been talking a lot about board size and what we do with the challenges that are facing us. And considering, among other things, one element I now know to blame Judge Fleming for, the requirement that that AIA cases finish in 365 days. Thank you for that. Only, I think it's the right thing. I think it's done wonderful things for the results we're talking about here, which is the preeminence of the PTAB. But imagine not only that you have 95 judges when there's work that's going to occupy easily 255, you have an embargo against growing, and when the work comes, you can't push it off in time because there'll be a congressional requirement as to when you finish it. Undersecretary Kapos and I, it was a second or third weekend in November, and there was debate going on about the next continuing resolution in Congress for spending, because of course we know our Congress still can't come up with a budget for the last quarter century. They operate with these continuing resolution things and are forever behind in figuring out how we spend our money. And it was not going to be possible, even if we were allowed to have the appointment of more judges, to actually pay their salaries unless Congress authorized us to do so. And the continuing resolution that would control the period going forward was under discussion. And Undersecretary Kapos was in discussions with the Office of Management and Budget at the White House as to how we handle all of that. And we came upon the realization, we are in serious trouble. We're done. If we don't both get the money and the authorization for the judges, 27,000 ex parte appeals are going to grow to 35,000 in about 6 to 8 months. We won't meet any AIA deadlines, and the PTAB, the BPAI, whatever this organization is, will have been declared a complete and utter failure as a way in which the patent world and the USPTO handles these issues. We were in talks with the White House for a good month before that continuing resolution included two things that were revolutionary. No ceiling at all on judges other than as necessary to meet the requirements of doing the work and whatever money was required to make it happen. That changed so much. What that led to was, over the course of 24 months, 2,300 applications for people wishing to serve as APJs, 1,600 that made it through to detailed consideration, 650 interviews of administrative patent judges, and the eventual appointment of about 160 of them. Completely game-changing. Now, you might say, well, okay, we overcame the problems. And again, this is just one of many kinds of things we were confronting. Here's another enormous headwind that I at least never anticipated. There were those folk at the USPTO who said, okay, you need lots of judges, and the opening of the offices and the authorization that you're looking for, there's a way around that. After an examiner has served 2 years, and if that person has a law degree and took a 3rd year trial practice class, they should be suitable for appointment, right? To me, that was about as outrageous a thing as I've ever heard, because of course, those who have done this work know the years of experience, judgment, study of the law required to have a crew of judges who can do what these judges do. I wish I had $1 for every piece of hate mail I received on the notion that the judges at the administrative patent judges, the PTAB, need to be at a level where what they write, how they write, is able to be an exhibit, not merely an exhibit, but part of the file of cases when they go to the US Supreme Court. Is that so wild a notion? Well, if it's wild, then actuality is wild, because some of the biggest cases in intellectual property law have had as their primary document for review the work done by the PTAB. I could easily go on about the history of the PTAB, at least seen from my little slice of time there for a long time, but I'm already over time. I would state one thing very emphatically that the others who have spoken have said. PTAB success, and I'll call what we've achieved all together as that rather than PTAB failure. PTAB success is definitely a team sport. There's no way you make this thing come together and cause the PTAB to be what it is without a whole lot of people working very hard, a whole lot of people working very hard. There are people who argue about what they think the PTAB does, how it decides cases. I've yet to hear any argument about the PTAB being equal to this task. And as my last personal note, and I maybe should have the discipline not to say this, but hey, I don't, at least not at this moment. During a period between 2013 and early 2015, my average workday started at 9 a.m., had dinner at about 9 p.m., maybe 8 p.m., went back to work, went to the gym across the street from the PTAB from about 10 to 11 p.m., came back to the office and worked the 11:30 to 2 a.m. shift, and often slept in my car and took a shower at that same gym before starting the next day. That's how much work we had to do. And there are a lot of people who worked that way to make this thing happen. I will say this, I am extraordinarily grateful that the people and the circumstances allowed little old me to have any hand in what the PTAB has done. Jim.
Thank you, Judge Smith, for that fascinating perspective on the birth of the PTAB, the hiring of judges from among thousands of applicants, and the PTAB's current significance. We appreciate your comments and your remarkable service and remarkably long hours to get the PTAB started and on course for the AIA and the PTAB success. And I join you in calling it that. Following Judge Smith, Nate Kelly was the acting chief and the deputy chief from 2015 to 2016. He is currently a partner at Perkins Coie. Judge Kelly.
Thanks, Jim. Just as it was 5 years ago, I guess 6 years ago, Chief Judge Smith is a hard act to follow. I feel today like a little bit like I felt at the board, which is something of a substitute teacher, getting us from one real chief judge to the next. You know, there's this joke that I'm sure a lot of you have heard, which is that the best 2 days in a boat owner's life is the day they get their boat and the day they get rid of their boat. You know, the worst 2 sort of emotional days in my professional career was the day I came to the board and then the day I left. I came to the board, it was sort of a shock to the system, to my system, I'm sure to the board system. I found out the week before, it was sort of made public basically the Friday before, and I was at a conference in California, Federal Circuit Bar Association conference. Chief Judge Bullock was there. And I showed up on Monday and I was at the board, and I just have never felt more uncomfortable in my life. And thanks to people like Krista Flanagan and Ken Barrett and Mike Tierney, and now I'm naming people and I'm going to forget, and of course Scott Bullock and Alan Cogswell, it all worked out from my perspective. And then by the time I left, it was very hard to leave. You know, I kind of liked it after a while. It took a while, but I got there. But while I was there, I felt like my job at the board was kind of like my job before, which was to defend the board. Like, I'm just going to defend it. And that's kind of what I felt like when I was there, because during that time, 2015 to 2016, there was a lot going on, right? So we sort of reached our cruising altitude. You've heard about the ramp up of judges. But when I got there, there were these vacancy announcements that were like every 30 days. We were like on vacancy announcement 40 or something. And there was like this system, right? There were the teams that were doing the paper review. There were the teams that were doing the in-person interviews. And then there was like, you know, people would filter through and then get to me. And I looked at something called the, what was it called? Like the unified plan or something like that, that Chief Judge Bullock understands completely. And I never really understood, and just stopped it. I said, okay, that's good. You know, Chief Judge Smith did an amazing job and couldn't have been done without those satellite offices. That is completely true. With those, I'm not supposed to call them satellite offices. With the regional offices, we got the resources, but more importantly, the talent pools that were not in DC. Not that DC doesn't have talent, but I think everybody gets what I'm saying. And that's what got us to 250 and then ultimately like 275 or something, but that was enough. And so we stopped that, and then we kind of had to adjust to that size. And that size was uncomfortable, I think, at first. It might be still uncomfortable, I don't know. But I felt like there were a lot of fires I had to put out with respect to what was going on with these judges and those judges. And I felt like that was my job, just to keep everybody happy and to keep it going. But a couple other things sort of manifested themselves at that time, and they're still around. And there were like a fundamental shift in the board, I think. And Mike Fleming mentioned this when he talked about the idea of giving the board rulemaking authority and more power to sort of shape what would happen. And indeed, you know, that's what happened, right? There's some policy room, there's some space within which now the board can operate. But with that came this pressure, like how would we do it? Would we do it through precedential opinions, which is how we had always done it and how we tried to keep doing it. It was difficult to get that many judges to vote one way or another on something. And I know the front office pushed me to get that done. And I know they pushed my successor to get that done. And I imagine he had as hard a time with it as I did. The downside of that, though, is we got this big change, right? We got a change about who was making this policy. And now the policy would be made with, I'm sure, the board's input and everybody else's input by a single person, by the director, who would just declare that's precedential, that's not precedential. And I don't know if that's the best place to be or not, but I think it puts the board in more of a policy position. And I don't know that that's a more comfortable position to be in, because what it means is the policy can start going one way and then it can start going another way, and then politics comes into play and judging becomes that much more difficult. And that brings me to the other thing that happened to the board, and maybe this was always there and I just never perceived it before. You know, there was this spotlight, this like white hot spotlight. I'm sure Chief Judge Smith felt it when he was there. I certainly felt it, and it has not dimmed at all. And it is great to be so important, but with that importance comes a lot of heat and a lot of people watching and a lot of people criticizing. And even today, like this week, I got an email from someone I've never heard of, you know, won't respond to. And it was basically like hate mail about my life at the PTO and what I caused to have happen. And I didn't cause anything, as far as I know, except to keep everything running on time for 10 or 11 months until I could, pass things along to Chief Judge Rushke. But that attention, that's just something I don't think the board felt before. And maybe some of the board did, but now, I mean, I have a lot of meetings talking about the PTAB, asking me what I think the PTAB will do. I don't know. And where it will go and how will this be resolved. And it is now like the dominant and most important policy part of the agency. It's what people care about. It's what litigants care about. It's what everybody thinks about as soon as they get sued, and it's what everybody thinks about before they decide to take their valuable patent and assert it. And that's just a difference, and it's a difference that the PTAB is, I don't know if I want to say stuck with, but I guess I'll wrap up and say that I felt a little envy when Chief Judge Smith was talking about this cement bunker 5 miles away from the city center. And there would have been times when I was at the board when I would have liked to have been in such a bunker. And my guess is that there are people at the board that would enjoy such a bunker today. Not that it's necessary, but maybe it's just me. I just want to keep my head down and do my job and get it done right. And all of the attention is not the greatest thing in the world, but I think it's at least the change I saw happen while I was there. So I think as a substitute teacher, I took more than my allotted time, and I will turn it back to you, Jim.
Thank you, Judge Kelly. Great perspective, and I'm sorry about the hate mail.
He's one of your clients, Jim, don't worry.
The next chief judge of the PTAB, as Judge Kelly mentioned, was David Rushke, who served as the chief judge from 2016 to 2018. Judge Rushke currently heads up the Central Reexamination Unit, the PTO's other post-grant organization. Judge Rushke.
Thanks, Jim, and thanks everybody. It's great to be with this group. And again, I wanted, if I start mentioning names and I leave people out, I want to apologize in advance for that. I guess I'll start just the remarks. I know we're running a little bit behind, but and please feel free to cut me off, Jim, as we go. But one of the things I think that I looked at my tenure as being in some ways kind of tumultuous, and it sort of follows on to what Nate was talking about, having the spotlight on you. It almost got to the extent that every single morning when you would look at the news clips, you were going to be wondering what article or what criticism of PTAB was going to be leveled at you. And because you knew that that would result ultimately in somebody from the 10th floor giving you a call asking, so what are we going to do about this? How can we respond to that? And so the spotlight was definitely out there. I don't know if you all recall, but this was also during the time period where a number of the inventor groups, the stakeholders, were quite upset with PTAB, and they leveled a lot of criticism at PTAB. In fact, they actually came onto campus and burned patents in front of the building at one point. They would attend PPAC meetings. And they would be downstairs in the Madison Auditorium during the presentation, pacing, sending questions, very, very pointed questions to us as we were trying to answer them during the presentation. So it was a very, very difficult time in some respects. Fortunately, I would like to say that I think a lot of that calmed down, and certainly has calmed down significantly with Andre coming on board. But there still is, like you say, there's still email that you'll still hear about it, and there's still articles being written, of course. And there's still constitutional challenges at the Supreme Court that have to be fought. I think the other reason it was a little tumultuous, I might say as well, is just because of the change in leadership. So I remember people asking me, why do you want to go and start a job at the government when there's another presidential election coming up in 4 months, and you don't know who's going to be elected and who's the new director going to be, et cetera, et cetera. And so we had a situation, of course, where I finished out Michelle Lee's for quote unquote first term. She was extended into her second term into the Trump administration. And then we had to essentially wait 13 months before Andre came on board. And we had Joe Mattal as our as our interim director. And then Andre came on in February, following the inauguration, a year following the inauguration. And that created a lot of difficulties because as we were talking about earlier, how do you create policy and how do you have consistent opinions on the board when the person in charge of the board is changing or is in an interim position? And it was very, very difficult for us to do. And as Nate mentioned, one of the levers we had, since rulemaking, although rulemaking would have been preferable in many situations and many of the judges wanted to do rulemaking, we had precedential opinions. And I think Mike said early on, you know, that was one way of doing consistency, which is absolutely true. But we had a difficulty on the board because, you know, if you remember, sovereign immunity, joinder, a lot of these very fundamental issues were coming down exactly on the opposite sides, one panel versus another. And we would run straw polls as to how the judges would feel about certain issues. And there were issues that literally came down 50-50, literally came down 50-50. So when we had the presidential opinion process of having to have a vote of the judges, it was almost impossible to get things through. We got a few things through, but I too was tasked with coming up with a new process to create that consistency, which would of course help the messaging and help the stakeholders understand what they could expect when they came to the board, and also help the judges understand how they would have to deal with this. And that was really important for us to do that. And that took about 2 years. We did a number of iterations internally to try to come up with different systems. Ultimately, it was replaced with the SOP right at the end of my tenure. And I think for better or for worse, there's certainly a lot of precedential opinions out there now that allow stakeholder interaction or input, but also director ratification, which I think has been very, very positive for the patent community generally. Although, as Nate mentioned, the new director can come in and that could potentially create some changes to existing precedent as we've been living with it for the last 2 or 3 years. So that was probably one of the biggest things during my tenure, was to try to come up with a precedential opinion process that made sense, that would be visible, and that would also help the notice requirement and make sure that everybody understood where the policy was headed. I would like to say, you know, the other thing that was a little tumultuous that we were talking about at the time is that we started up at the Supreme Court. I was lucky enough within 1 month of starting, Quoza was decided. While that wasn't maybe necessarily a significant sea change for us, ultimately we had oil states and SAS, and then we had aqua products at the Fed Circuit. So we had a lot of cases going on with the Supreme Court getting involved. And as James said, it was definitely true when the Supreme Court knows what PTAB stands for. And if you'll indulge me, Jim, I'll say one little anecdote. When we were up there for oral argument, and Nate, you were in front of the bar during the SAS oil states argument, and when the solicitor was giving an argument on and trying to explain to the justices about how the expanded panel process used to work, he was explaining how the chief judge of the PTAB has authority to expand panels, to which Justice Roberts interjected immediately and said, Chief Judge, you mean the employee? And so I always thought of that as sort of like my 5 seconds or 10 seconds of fame in front of the Supreme Court, that at that point in time, he was referring to the chief judge of the PTAB as an employee. And of course, we have Arthrex out there, which is now going to be telling us exactly what kind of employees APJs are. But I think that brings the perspective around perfectly of the spotlight and what the PTAB means out there. I mean, and there's more cases obviously to be decided. I'm not going to go too much into it. I just want to say a couple more points. One of the things, because we didn't have a permanent director in place for so long a period of time, one of the things I'm very proud of that we did at the board was pull together a lot of people, judges, patent attorneys, admin folks, to pull together statistics. Because we always thought, you know, instead of just arguing with people and trying to be on panels and trying to put our best face forward, let's just pull together the real data that we have at the PTO. And let's present that as frequently and as often as we can. And I really appreciate all the hard work that the teams did. I gave many speeches on data, as did Jackie and Scott, and among a number of the team members. And I hope that that really helped, particularly with respect to multiple petitions expanded panels, use of 325D, multiple proceedings, things like that. I think that's really helped, and I'm glad to say that the board has really done a great job since my time keeping going on that, because it really, I think, makes a difference out there, and people actually have the reality of the PTAB as opposed to the mythology of the PTAB. And lastly, I know I didn't have to hire like James did. We did do a reorg, if you will. We sort of had grown up at that point when I came on board. And Scott and I spent many hours in interviews as we were trying to move the judges around into a structure that actually made sense. And I really wanted to thank Scott and Jackie. Jackie was the recipient of that. She was essentially our first vice chief judge at the time. And she's obviously done a great job up there. And that was really important, I think, for the board to have some sort of firm structure going forward, since they had that huge growth spurt underneath James. And that was a tough thing to do. So nothing that I had to do rose to that extent. But I do remember we weren't sure what the new president was going to do. And Scott and I were frantically trying to get enough of the hires in on January 19th before the new president came in, because we wanted to make sure that we could hire and we could reorg to make it as functional as possible as we could over the next two to 3 years. And finally, lastly, one of the things, Nate talked about what his, some very important days in his career. I have to tell you, there was two things that happened with me, and they were really with PTAB initially, and that was we hadn't over time really done official swearing in ceremonies for the judges. And so very early on in my tenure, we had a big ceremony in Alexandria, but we also went out to all 4 regional offices and swore in the new judges that hadn't been sworn in. That was so meaningful for them because they were able to bring their families, their children, dignitaries. We had other judges in the area come in, and that was really, really important. And the second big piece that we had was our in-person all-hands meeting that we had, where we brought 400. Every single person from the PTAB came on campus in Alexandria for 3 days. I never got a chance to meet every single person individually up until that time. And now, of course, in this time of COVID, when everybody is doing Zoom and not meeting in person, I look back on that with an extreme pleasure that was something that was very important to bring, continuity to the board, bring everybody together, get a chance for them to have lunch together, have a drink, go on a walk. And that, to me, was probably one of the biggest accomplishments when I look back at my tenure, was being able to do that for the board. So I'll leave it at that, Jim, and thanks again for setting this up. It's a great program.
Thank you, Judge Rushke. The change from straw polls to a precedential opinion process certainly provides some needed certainty, and the development and publication of statistics really did help with understanding the reality of the PTAB as opposed to mythology. The swearing in process and the all hands meetings were also important developments. Thanks to COVID, obviously we can't do the all hands meeting, but at least people are no longer burning patents on your doorstep.
No, they're not.
That. Next, we have Deputy Chief Judge Jackie Bonilla. Judge Bonilla has been the Deputy Chief of the PTAB since 2019 and was acting Deputy Chief starting in 2018. Deputy Chief Judge Bonilla, take it away.
Thanks. I just want to say that it is really just such an honor to be here with everybody that is speaking. It's just, and listening to the extent I had any doubt, which I didn't already, but just the magnitude of the giants that preceded us and the forward thinking that you had. Honestly, I can tell you, and I'm going to talk a little bit about this, but I benefited from that, and we all did at the board. It's just, it's quite incredible. So thank you for that, and thank you for including me as part of this conversation. I was trying to think what I could cover that would be different from what other people who are talking today might cover. And with that in mind, I thought I would talk about 2 things. The first one is my perspective coming on as an APJ in 2012. That's sort of an interesting time to arrive and sort of, experience everything we have up through today. And then also I thought if I have time, I would talk a little bit about the history of women at the board, because I think that's pretty interesting. So for the first thing, I was obviously hired as part of a big wave of hiring that happened BPAI in 2012, and then what became PTAB. I started in January of 2012. I started with Erica Franklin and Debbie Katz. They had started a few weeks before me in December. And we were the first APJs that were hired after AI passed in September of 2011. Notably, earlier that fall was the first time that APJ positions were open to people, what I'll call general public practitioners. Prior to that, it was very difficult to get hired from private practice or even from the federal government outside the USPTO. I mean, it did happen, you saw it, but it was so rare that most people didn't know about it, or they thought it was impossible. I know I did. When I started, I was literally judge 100. I still have that piece of paper that shows the list of the judges, and I was exactly 100 the day that I started. And in the meantime, PTAB, obviously skyrocketed in hirings, as we've already talked about. It went to its highest level at, I believe, a little over 270 in 2016. So that's an increase of 170 judges since I arrived. Obviously, that's, and a large majority of them, by the way, coming from the outside of the board or outside of the USPTO. So that's a big change. And just to keep it in perspective, as somebody who, was in private practice before I got here, that's the equivalent of hiring a mid-sized law firm, but doing it piecemeal, which is just kind of incredible when you think about it. I'm just overwhelmed with awe at the lift that was. But we started, we plateaued in size around 2016 and then went down slightly. So right now, due to natural attritions and retirements, we're at about 250. But when I arrived in 2012, it was a really incredible time to come to the board. I just met so many fun, brilliant people, both new and experienced at the board. And especially when I very first got there that first year, there were so many people, there were so many new judges arriving all at once. And everybody was super excited to be there. They were thrilled to grab lunch. They were thrilled to go to somebody's office and chat. I mean, I honestly think it was like participating in a fun summer camp for smart patent attorneys. Like, it was just all these people were coming together and were just super excited. And then, of course, as already mentioned, around the same time, all four of the regional offices open. The PTAB was leading the charge there, and we met lots of new friends that way too. So we're plugging along. The ex-party backlog was huge, but it was coming down. AIA cases were getting started in earnest. And people touched upon this already, but I had it as something I was going to mention too, is that all of a sudden PTAB was in IP news a lot. And it was both good and bad, and both true and frankly untrue. Everybody wanted to know what was going on, and they had something to say about it. And this is just a huge change, because even in late 2011, when I applied, the board of who worked there, what they did, how they did it, it was a black box. I mean, I remember I did my own diligence to find out what I could about the board when I was applying, and I was like, there was very little to find out. But in the meantime, especially like Nate said, by 2015, we started seeing all sorts of press, and there was a lot of inaccurate perceptions and misinformation about the board. I think that's really new. There's lots, we can all speculate as to why that was, but I think it was basically that, all of a sudden, a lot of people were issuing board decisions that had a really big impact on IP litigation. It wasn't just rarely or below the radar like it had been before. It was happening a lot. And you saw these big name IP litigation firms and big name IP litigators were taking notice and talking about it. This was a big change, and a lot of people don't like change. They like things to keep a status quo. So, that's a big deal too. One example of the perception issue was the label, and I know some people tell me I'm not supposed to talk about this, but the label of the patent death squad. And I think it's really interesting to keep in mind that Judge Rader coined that term at a presentation that he gave at AIPLA in October of 2013. The interesting thing about that is in October of 2013, the PTAB had not issued a single final written decision yet or found a single claim unpatentable in an AIA trial. The first time that happened was in our very first final written decision that issued in November of 2013, a month later. So you could see that some people already had a bias about what we were doing and how we were doing it before we even actually did anything. So it was in this environment that, meanwhile, I became a lead of a brand new section in 2015. We needed a bunch of new sections because of the growth. I think Judge Fleming talked about, they had set up the board structure so that it could grow. And I can tell you, I saw that firsthand, how we did that. And then I became a vice chief in December 2016. And this was a part of an entirely new structure at the board. David had talked about how David and Scott had put together this entirely new structure of board executive leadership. This was with 5 vice chief judges and our board executive and so on. And it was, I just have to say from my own place, my own perspective is that, having the perspective of being a regular judge, doing the ex parte cases and the interferences, I was lucky enough to do those early on, and then doing AIA and being mentored over the years by all these experienced and newer judges too, because, everybody was learning this as we go. I mean, a lot of it was just so new. It's just been incredibly valuable and incredible. Everybody is so smart and thoughtful and just amazingly congenial. It's just been such an amazing time to be at the board, I have to say. So with that, if I have time, I'll pivot a little bit just to give a little bit of history about women at the board. This was something I was interested in. So I looked in a little bit. I talked to some of the people on this call. I talked to other judges and just sort of got a little bit of history. And I think it's pretty interesting. So first off, I'll say it was true in 2012, as it is today, actually, that the board is about 1/3 women. But in terms of board history, it's been around in some form since the 1860s. Having any women at the board at all is relatively new. As near as I could tell, based on my research, the first woman at the board was a woman named Brett Sturdivant, who was appointed by President Nixon in 1971 as an examiner in chief. Back then, the board was small enough. I think it was only 15 people. And she actually got a call from the White House about her job, just to give you that perspective back then, which is interesting. Meredith had actually given me a website of a Penn State recording and transcript of an interview with her. And I have to say, hopefully when we send out this transcript of this meeting, maybe she could pass along that website, because I looked at it. It's just fascinating to see her life and how she came to the board and everything else. So I highly recommend that read. But after she came to the board in 1971, there were 2 more women who were appointed in 1974. Then 2 came in 1985 and 1986, respectively. And just to give a little bit more perspective, many of you probably know Adrienne Hanlon. She has been at the board for a long time. But interestingly, this is a woman who's approximately my age, my contemporary and colleague. This is the 6th woman at the board ever in its history. Adrienne Hanlon is the 6th woman at the board ever. And Murriel Crawford, one of our esteemed colleagues who's on the phone right now, she became the first woman of color at the board ever in its history. And Murriel was also the first woman to sit on mechanical and electrical panels. Up to that point, the women APJs had been in the chemical bio area. And it's just stunning to me, because this is not that long ago. And from my own perspective, I graduated from graduate school in 1995 and from law school in 1998. I mean, this is not that long ago. And then just to give another perspective, women in leadership at the board in any capacity, that's new too. That started with the formation of the lead judge position in the mid 2000s. Linda Horner and Sally Lane became lead judges in 2007 and 2008, respectively. And then a number of other women became lead judges in 2011, around the same time that the lead judges started acting in direct supervisory roles of sections. And Linda Horner also served as an acting vice chief starting in 2013. She was the first woman to serve in any executive role, acting or otherwise, at the board. And after her, there was Barbara Benoit and Miriam Quinn. They served as acting vice chiefs in 2014 to 2015. And the board saw its first woman in a non-acting SCS role when Janet Gongola became vice chief in October of 2016. And then Grace Oberman and I followed soon after in December of 2016. So I bring this up because it's worth keeping in mind how things were not very long ago at all. When, I know a big topic today is, issues of diversity and inclusion. And I think we've made great strides at the board through hard work of a lot of champions, including people on this call. But we still have some ways to go. And so I think keeping that in mind and talking about our history really helps, both in terms of this And in terms of the things that Judge Stoner and Judge Fleming talked about, that was just fascinating to me to hear that history, especially because if we run the risk of repeating some of those mistakes if we're not aware of it. So with that, I will pass the baton, and thanks again for including me.
Thank you, Deputy Chief Bonilla. I started at the board not too long after Judge Adrienne Hanlon, and so I'm stunned to hear that she was only the sixth woman on the board. I enjoyed your remarks about the summer camp environment. It certainly sounds nicer than Death Squad. Now, to cap it all off, we have Chief Judge Scott Bullock. Chief Judge Bullock was acting deputy chief of the PTAB from 2014 to 2015, deputy chief judge from 2016 to 2018, acting chief judge from 2018 to 2019, and has been the chief judge of the PTAB since 2019. Chief Judge Bullock has been a good friend to the AAPJ, and we're very grateful for that. Chief Judge Bullock.
All right, thank you, Jim. You know, I do apologize because I realize I'm already late here, or we're overtime, and I'm tempted to just quote Salvador Dali and say that I'll be so short that I've already finished. But sadly, I will say a few things here just in case. I'm really surprised that I've been watching that participant number and it's holding steady so far. We'll see how long that lasts. Anyway, there's been a couple of folks I know, both Jay and Jackie talked about kind of standing on the shoulders of giants, and I really do feel that way, both for myself, my career at the board. In a sense, the AIA is that way too, as Bruce Stoner and Mike Fleming recalled in the early days, in the early history of how it came to be. I just have to say that really, I do owe my career here at the board to Mike Fleming and Gary Harkcom, who is unfortunately, I guess, not here tonight. They hired me, and I have some of my mentors in my early days are on the phone, including Ken Hairston. I spent many hours in Ken's office learning the trade, and Al McDonald's not on the phone, but I also spent a lot of hours in Al's office, learning what to do and what not to do. Great folks all around. All of my predecessors in the executive ranks here at the board have been folks that I've just learned so much from. Starting with Mike Fleming and going all the way up through. To David. I feel like, I've learned so much and really regard them all as mentors and friends. It is really a special position that I just feel like it's kind of the honor and the challenge of a lifetime. Running the board, I often thought it's probably the easiest job there ever could be, because you've got all these really smart, talented people. But as we've heard from, the other speakers here tonight, believe me, there are plenty of challenges, some of them sounding quite familiar. It does seem that history repeats itself in some form. Have since I joined and came to the position I'm in now, I think I have occupied every position that a judge could have at the board, including an APJ, what we had for a while as a supervisory APJ when Eric Chen reported on board as a patent attorney, and then thanks to Jay and James, I got into management and became a lead judge, and then a vice chief judge, at times both a vice and an acting vice chief judge. I think I was the entire, and was sort of the entire other executive. I do recall what Jay said brings back memories of signing lots and lots of reviews in October, in April. I think at the time I had about 200 there. So April and October were not my friends in those days. Luckily, we've grown and we've made up. So right, the board, I was number 53 when I joined. And as you heard from Jackie, we're now, we grew past 250, but we're sort of back down to around 250. We've grown, as you heard, and not only in size, but in location, spread out across the country. We're now in a position where, well, you know, telework was normal even before the pandemic, and now it's totally normal. You know, the ways that we work have evolved. I do recall some legacy paper files when I first arrived, and there are a number of them still in a filing cabinet somewhere on the floors of the board, but you just don't see those anymore. I just have to say that you know, you really don't know what you're getting into as you rise up through the organization. And you know, looking back now, I really do appreciate so much more all that my predecessors have done, and how much they really dealt with that you never know or never find out. And that's kind of a good thing, that I've sort of viewed part of the position as trying to be a firewall so that the judges can just concentrate and do their jobs. But as you've heard, there's a lot going on, you know, both within and outside the PTO. And I sort of feel, you know, my job's to absorb that and not, you know, let it bog down the judges in doing the job that they have to do. Now, you don't get to do that alone. Without the team that I have, I would never succeed. And so I really am so fortunate to have a great leadership team and, you know, so many wonderfully talented judges on the board. You know, I just have to I run the risk of the Academy Awards of, you know, leaving somebody out. I'm sure that I will, and I do apologize. But you know, the team that we've got, really in my mind, second to none. I've never worked with a you know, better team, including you know, Jackie as a deputy chief judge, with Mike Tierney and Scott Wiedenfeller, Janet Gongola and Mike Kim as our vice chief judges, and Troy Tyler as our board executive. But also behind the scenes, really without people like Krista Flanagan and Andrew Nalvin, the board doesn't work. They truly do keep things going, as well as our executive assistants. And we have now two senior lead judges, Cal Deshpande and Melissa Hoppala, who are also kind of helping us, as well as all of the lead judges who now have become too numerous to really name here in one sitting, but they all really contribute so much, as well as the very talented and you know, wonderful judges and patent attorneys and staff of the board operations division. So as I say, it really is, it's a great team. We have our challenges, but you know, I really wouldn't have it any other way. Shifting to the AIA, the thing that I think is really interesting about this is I, you know, sort of did see it. I remember, you know, watching the, you know, the voting, and for a while it really seemed like that sequence of Charlie Brown with Lucy and the football, of Congress taking a run at it, and it didn't work. And then in 2011, it finally did. And just, you know, being there as part of the activity and watching that whole thing transform, it really was remarkable. But I guess what I've learned is you're never done, and I don't think we ever will be. There's always issues that come up that you never would have anticipated. I mean, who knew that we'd ever have to look up sovereign immunity after law school? You know, who knew that an appointments clause would be a thing? So many issues. Who knew that we'd get 6 trips to the Supreme Court, including one day when the entire hearing session of the Supreme Court were 2 back-to-back PTAB cases? So just kind of remarkable. And then on top of that, now we have a global pandemic on top of all of that. And the amazing thing is, because of the hard work of my predecessors and the team here now, and all the judges and staff of the PTAB, we didn't miss a beat. They locked up the PTO on a Friday, and on Monday we opened virtually, with a complete set of hearings, and we've really never looked back. So I think that speaks a lot to the spirit, and the just determination to get things done of the people at the board. And I think, it's been that way, and continues to be that way. I don't want to keep everybody here. I could tell tales all night long, just because it is a place that I care a lot about, and I think we all do. The fact that you're still here, and I've only lost 2 people during my speech, tells you that that's not too bad. Anyway, thanks so much, Jim, for putting this program together. I thought it was really great. Brought back tons of good memories, and we'll see what the next chapter holds in store for us. But I just know it's going to be exciting. So thanks.
Thank you, Chief Judge Bullock, and thank you for your gracious acknowledgement of everyone making the PTAB the well-oiled machine it appears to be. And we won't hold you to the Academy Awards standard, but you're right. It's difficult to name everybody that's pulling together as a terrific team that you have put together. And Chief Judge Bullock, your contributions cannot be overstated. And I think I speak for everyone when I say I hope you and Vice Chief Judge Bonilla continue running the PTAB for a long, long time. This has been a very informative session, and it is the first true history of the PTAB from the leadership perspective. The AAPJ is grateful to all of you for your participation and your exceptional service to your country. You have made the world a much better place, and we thank you for it. A mission of the AAPJ is to honor and preserve the history of the board. So if I could ask the 8 speakers to turn on your cameras and stay on for a group screenshot of the speakers for the AAPJ archives, we're going to attempt that, and it would be most appreciated. And to everyone else, thanks for listening.